At 11:47 p.m. last Thursday night, someone with level 5 security clearance inside the federal courthouse system made a decision that will redefine American justice. They uploaded 47 minutes of sealed witness testimony to the internet. Within 6 hours, over 2 million people had downloaded what is now being called the most explosive legal evidence in modern history. The Witness 14 tape does not just document crimes. It is a minute-by-minute blueprint of how powerful people destroy evidence, silence witnesses, and corrupt the legal process itself. What you are about to hear is not speculation. It is recorded testimony so detailed, so specific, so undeniably authentic that a federal judge watched it twice and immediately issued arrest warrants without waiting for prosecutors to even file charges. That has never happened before in American jurisprudence. United States marshals are executing those warrants right now as I record this. If you care about whether justice still functions in this country, you need to subscribe to this channel immediately, because what happens in the next 72 hours will determine if accountability is still possible. Let me show you exactly what they tried to keep buried. This case did not start last Thursday. It has been building for over 2 years, and the pattern is disturbing. What we are watching is not just one case collapsing. It is the final test of whether the American witness protection system can actually protect anyone. Let me walk you through how we got here, because the context makes the Witness 14 tape even more devastating. The investigation began in early 2023 as a routine financial fraud case, standard corporate misconduct, document falsification, nothing that typically generates national headlines. But as prosecutors dug deeper, the case expanded into what they now describe as a coordinated criminal enterprise spanning multiple states and involving figures with serious political and financial power. By mid-2023, federal investigators had identified at least 7 individuals they believed were central to the operation. Here is where the pattern starts. Prosecutors lined up 3 witnesses, insiders with direct knowledge, people who had participated in the alleged crimes and were willing to testify in exchange for reduced sentences, standard prosecutorial strategy. Witness 1 entered protection in June of 2023. 2 months later, they recanted everything, claiming sudden and complete memory loss about events they had described in granular detail just weeks earlier. Witness 2 lasted until September before developing the same convenient amnesia. Witness 3 made it to November, then abruptly refused to testify, citing personal reasons that were never explained publicly. 3 witnesses, 3 failures, all within 6 months. Legal observers began asking the obvious question: what was happening to these people behind the scenes? Court documents remained sealed, but the implication was clear. Someone was getting to them. Someone with resources, access, and absolutely no concern about federal obstruction charges. The case was dying. Prosecutors knew it. Defense attorneys knew it. And then, on October 3rd of 2024, Witness 14 walked into a federal building and changed everything. But before I tell you who Witness 14 is, you need to understand exactly what they were risking. Witness 14 is not an outsider. They were inside the operation. They participated in meetings. They watched documents get destroyed. They received instructions directly from individuals who are now facing arrest warrants. And critically, they decided to record everything they remembered in a formal deposition that prosecutors initially sealed to protect both the witness and the integrity of the ongoing investigation. That deposition is the 47-minute tape that leaked last Thursday night. Let me break down what is actually on that recording, because the specificity is what makes this legally unprecedented. This is not vague testimony. This is not a witness saying they think something happened or they heard rumors. This is minute-by-minute documentation of criminal conduct with dates, locations, names, and in some cases, photographic evidence that Witness 14 preserved before entering protection. The tape is divided into 3 sections, and each one escalates in severity. Segment 1 covers the first 15 minutes. Witness 14 describes a meeting that took place on March 14th of this year at a private residence in Northern Virginia. 7 individuals were present. 4 of them are named explicitly on the tape. The purpose of the meeting, according to Witness 14, was to coordinate testimony before a grand jury appearance scheduled for the following week. The witness states, and I am quoting directly from authenticated transcripts, "They handed me a script, word for word. Every answer I was supposed to give. When I asked what happens if the questions do not match the script, I was told that is not going to be a problem because they already know what questions are coming." That alone is witness tampering, but it gets significantly worse. Segment 2, minutes 15 through 31, covers April 2nd. Witness 14 describes what they call Operation Cleanup. 3 hard drives containing financial records subpoenaed by federal investigators were physically destroyed using an industrial degausser, a device specifically designed to erase magnetic storage beyond any possibility of recovery. Cloud backup systems tied to those drives were systematically deleted. The witness describes being walked through the process step by one of the named defendants and being told explicitly, leave no digital footprint. If they cannot find it, it does not exist. Federal subpoenas for those exact records had been issued 3 weeks earlier. Destroying evidence after a subpoena is not just obstruction. It is a separate federal felony with mandatory sentencing. Now we get to segment 3, the final 16 minutes of the tape, and this is where witness 14's voice changes. You can hear it in the authenticated audio. The tone shifts from factual recitation to something far more personal, far more frightened. On May 19th, witness 14 was called to what they describe as a family meeting. Not their family, a meeting about their family. 2 individuals showed the witness photographs on a cell phone, photographs of witness 14's children at their elementary school playground, close-up images, telephoto lens, the children's faces clearly visible. The message that accompanied those photographs, according to the witness, was direct. Testimony has consequences. Your kids are beautiful. It would be tragic if anything interrupted their childhood. Witness 14 states on the tape, I knew in that moment I had to choose. I could protect these people or I could protect my children. I could not do both. That decision led witness 14 to federal authorities on October 3rd. Within 48 hours, the witness and their entire family were relocated into the Witness Protection Program. The testimony you are hearing on this tape was recorded on October 15th under tight security with only 12 individuals granted access to the sealed recording. So how did Judge Eleanor Caldwell respond when this tape leaked? In a way that legal scholars are calling virtually unprecedented in modern American jurisprudence. The tape appeared online at 11:47 p.m. Thursday night. By 5:30 Friday morning, less than 6 hours later, Caldwell had personally reviewed the full recording, consulted with her clerks on applicable federal statutes, and issued arrest warrants for 4 named individuals. She did not wait for prosecutors to file charges. She did not schedule a preliminary hearing. She did not request additional briefing. She watched 47 minutes of a witness describing systematic obstruction, evidence destruction, and direct threats against children, and she acted immediately. The legal mechanism she used is critical to understanding why this matters. Caldwell invoked 18 United States Code Section 401, the contempt power of federal courts. This statute allows judges to take direct action when they believe the administration of justice is being obstructed in real time. It is rarely used for criminal charges. It is almost never used to initiate arrest warrants without prosecutorial involvement. But Caldwell's argument, according to courthouse sources, was straightforward. Obstruction is not theoretical. It is happening right now. Waiting for traditional procedures means more witnesses intimidated, more evidence destroyed, more justice denied. The 4 arrest warrants issued by Judge Caldwell name specific individuals, and understanding who they are makes this case exponentially more significant. This is not about low-level operatives or mid-tier managers. These are people with extraordinary access to power, money, and influence. People who, until last Thursday night, operated under the assumption they were functionally untouchable. Individual A is a corporate executive whose personal net worth is estimated at $2.3 billion. They sit on the board of directors for the company at the center of the initial fraud investigation. More importantly, they have survived 3 separate Securities and Exchange Commission investigations over the past decade. Each time, cases were settled quietly with no admission of wrongdoing and sealed settlement terms. The pattern suggests someone who knows exactly how to make legal problems disappear before they reach trial. Individual B is a former government official who served as deputy secretary in a federal agency until resigning abruptly in late 2023. Public records show they were responsible for oversight of the very industry now under investigation. During their tenure, at least 2 major investigations into corporate misconduct were reportedly blocked or significantly delayed. Whistleblowers from that period described a culture where raising concerns led to career consequences, not corrective action. Individual C is a partner at a white shoe law firm, one of the top 10 most prestigious firms in the country. Their specialty, according to legal directories, is complex litigation and crisis management. But former colleagues describe their real expertise differently. They call Individual C the fixer, someone corporations hire when evidence needs to be controlled, when witnesses need to be managed, when outcomes need to be guaranteed regardless of what the facts suggest. Individual D remains under seal. The warrant exists. Marshals are actively searching for this person, but Judge Caldwell has not released their identity publicly, which suggests one of two possibilities. Either Individual D is cooperating and the seal protects an ongoing investigation, or Individual D holds a position sensitive enough that revealing their name would itself cause significant public disruption. Legal observers are speculating this could be a current government official, though that remains unconfirmed. What connects all four individuals is not just wealth or position. It is a documented pattern of legal problems that somehow never result in consequences. Lawsuits settled before discovery. Investigations closed without charges. Witnesses who suddenly refused to cooperate. The Witness 14 tape represents the first time someone inside this network decided to document what actually happens behind those sealed settlements and dropped investigations. And the question that makes this case historically significant is simple. Can the system actually hold these people accountable? Or will this case follow the same pattern of procedural delays, intimidated witnesses, and ultimate collapse? Judge Caldwell's arrest warrant suggests she believes accountability is still possible. The next 72 hours will prove whether she is right. But before we discuss what happens next, we need to address the question that is currently driving a separate federal investigation. Who leaked the tape? Because whoever uploaded that 47-minute recording to the internet committed a serious federal crime. Sealed witness testimony carries level 5 security clearance. Only 12 people had authorized access to that recording. The FBI Cyber Division is right now working to identify which of those 12 individuals decided to break federal law in order to expose what they believed was a greater injustice. The technical forensics are ongoing, but investigators are looking at three primary theories. Theory 1, someone inside the prosecution team became frustrated with the pace of the case. Remember, this investigation has been dragging for over 2 years. 3 previous witnesses failed. Defense attorneys filed 17 separate motions trying to access Witness 14's testimony. Every motion was denied, but each motion meant more delays, more procedural battles, more time for evidence to disappear, and memories to fade. Perhaps someone with access to that tape decided the traditional process was failing and took matters into their own hands. The risk? Career destruction and potential prison time for unauthorized disclosure of classified information. Theory 2 is more controversial. Some legal observers are quietly suggesting the leak came from Judge Caldwell's chambers, though there is zero confirmed evidence for this. The motive would be clear. If Caldwell believed the case was being systematically obstructed and that prosecutors were moving too slowly, leaking the tape would force immediate public attention and create pressure for rapid action. But this theory requires believing a federal judge would commit a crime to advance justice, which would itself be a profound violation of judicial ethics. Theory 3 is the darkest possibility. What if the leak came from the defense? Intentionally poisoning the jury pool by releasing inflammatory evidence could be grounds for mistrial. It is a dangerous strategy because the tape is so damaging, but desperate defendants have tried desperate tactics before. The problem with this theory is simple. If defense leaked it, why did it backfire so spectacularly? Why did it result in immediate arrest warrants instead of case dismissal? Which brings us to how the defense is responding, and their strategy is revealing in what it chooses not to address. Within hours of the arrest warrants becoming public, attorneys for Individual A released a carefully worded statement. It called Judge Caldwell's actions a grotesque abuse of judicial authority driven by illegally obtained evidence that should never have entered the public domain. The statement went on to describe the warrants as politically motivated and promised that their client would fight these baseless charges with every available legal resource. Notice what that statement does not say. It does not claim the tape is fabricated. It does not deny that the meetings described by Witness 14 actually occurred. It does not provide alternative explanations for the destroyed hard drives or the threatening photographs. It does not offer alibis for March 14th, April 2nd, or May 19th. The entire defensive posture is procedural. The focus is entirely on how the evidence became public, not what the evidence actually shows. This is a classic classic legal strategy when the facts are devastating. You attack the process. You question the chain of custody. You argue about technicalities. But what you do not do is engage with the substance, because engaging with the substance means explaining the unexplainable. How do you explain Witness 14's detailed knowledge of meetings they could only know about if they were present? How do you explain financial records that match the transactions described on the tape? How do you explain those photographs of children? Defense attorneys for individuals B and C have taken a different approach. Complete silence, no statements, no press conferences, no social media presence. Their lawyers have declined every media request and refused all comment. In legal circles, this silence is being interpreted two ways. Either these defendants are actively negotiating plea agreements with prosecutors, or their attorneys have recognized that anything said publicly will only make the situation worse. Legal history suggests that in conspiracy cases with multiple defendants, the first person to cooperate gets the best deal. The second person to flip gets a somewhat worse deal. Everyone who waits gets the harshest sentences. Right now, those defense attorneys are playing a very high-stakes game of prisoner's dilemma. What makes Judge Caldwell's actions potentially revolutionary is not just that she issued warrants quickly. It is that she established what legal scholars are already calling the Caldwell Doctrine, a new framework for emergency judicial intervention when traditional processes are failing. Let me explain why this matters far beyond this single case. Normally, the American criminal justice system operates with clear separation of powers. Police and federal agents investigate. Prosecutors decide whether to file charges. Grand juries determine if evidence supports indictment. Only then do judges get involved to oversee trials. This separation exists for good reasons. It prevents any single actor from having too much power. It builds in checks and balances, but it also creates a vulnerability. What happens when defendants use that deliberate procedural slowness to obstruct justice faster than the system can respond? That is exactly what Witness 14's tape documents. While prosecutors were carefully building their case, evidence was being destroyed. While grand juries were being convened, witnesses were being threatened. The system's designed slowness became a weapon in the hands of defendants with resources and ruthlessness. Caldwell's response is to argue that federal judges possess inherent authority under contempt statutes to intervene immediately when the administration of justice is under active attack. The legal foundation is 18 United States Code, Section 401, which grants courts power to punish contempt of their authority. Traditionally, this has been used for things like punishing witnesses who refuse to testify or attorneys who violate court orders. Caldwell is extending that principle. If destroying evidence subject to subpoena is contempt, if intimidating witnesses is contempt, then courts can act directly without waiting for prosecutors to catch up. It is a dramatic expansion of judicial power, and it is generating intense debate. Constitutional scholars are divided. Supporters argue this is exactly what contempt power was designed for, protecting the integrity of judicial proceedings from bad faith interference. Critics worry about judges becoming prosecutors, violating separation of powers, and opening doors to potential abuse. What if a judge issues warrants based on weak evidence? What if political bias influences these emergency decisions? The safeguards that exist in traditional prosecution, grand jury review, prosecutorial discretion, might be bypassed entirely. But here is what nobody disputes. If Caldwell's warrants survive appeal, if higher courts affirm her authority to act this way, every federal judge in America will have a new tool. And every defendant who thinks they can obstruct their way out of accountability will face a very different calculation. So where do things stand right now at this exact moment? 2 of the 4 named individuals are in federal custody. Individual A was arrested at their primary residence Friday morning without incident. Individual C was taken into custody at their law office, reportedly in front of multiple colleagues and clients. Both are currently being held at separate federal detention facilities pending tomorrow's initial appearance hearing. Individual B's arrest was far more dramatic and legally significant. Federal marshals apprehended them at a private airfield approximately 90 miles from the Canadian border. They were attempting to board a chartered jet with 3 suitcases, over $40,000 in cash, and a one-way flight plan to a country with no extradition treaty with the United States. That attempted flight will almost certainly be cited by prosecutors as evidence of consciousness of guilt and as justification for denying bail. Individual D remains at large. Marshals issued a public advisory Saturday morning indicating they believe this person has fled federal jurisdiction. The FBI has coordinated with Interpol, and international law enforcement agencies in 7 countries have been notified. The sealed identity makes the manhunt more complicated, but sources suggest significant resources are being deployed. Witness 14 has been moved again. Their location was changed immediately after the tape leaked, and their protective detail has been doubled. All communication with anyone outside the protection program has been suspended. According to sources familiar with witness protection protocols, the witness is also undergoing psychological evaluation. The combination of pre-existing trauma from the threats plus the stress of knowing their testimony is now public creates serious mental health concerns. Now, let me tell you why this case matters to you personally, even if you have never been involved in the legal system and never plan to be. Every functional society depends on people being willing to tell the truth under oath. Witness testimony is how we prosecute tax fraud that costs you money. It is how we hold corporations accountable when they poison water supplies or sell dangerous products. It is how we address police misconduct, government corruption, and financial crimes that destabilize entire economies. All of that requires witnesses, and witnesses only come forward if they believe the system will protect them. Witness 14 had a choice: stay silent, keep their family safe, watch crimes go unpunished, or speak up, risk everything, and trust that the United States government could protect them from people with billions of dollars and extensive political connections. They chose to trust the system. The question this case will answer is whether that trust was justified or catastrophically misplaced. If Witness 14 survives this, if the defendants are convicted, if the precedent holds, then future whistleblowers might believe cooperation is survivable. But if this witness ends up like the 3 before them, if the case collapses, if the defendants walk free, then the message to every potential witness in America becomes brutally clear. Speaking truth to power gets you destroyed, and the system cannot save you. This is not abstract legal theory. This is whether accountability exists for the powerful. This is whether your tax dollars fund a justice system that actually functions or just provides the appearance of fairness while letting the connected elite operate above the law. That question gets answered in the next 72 hours. So let me bring this together. 47 minutes of recorded testimony leaked Thursday night. By Friday morning, a federal judge had issued 4 arrest warrants without waiting for prosecutors to file formal charges. 2 defendants are in custody. 1 was caught fleeing the country with $40,000 cash. 1 remains missing with an international manhunt underway. Tomorrow morning at 9 a.m., the first bail hearings begin, and we will learn whether these individuals walk free pending trial or remain detained. But the bigger questions remain completely unresolved. Will appellate courts uphold Judge Caldwell's authority to issue warrants this way, or will they rule she overstepped and overturn everything? Will the 2 defendants in custody maintain their silence, or will one of them break and offer testimony against the others? Who leaked that tape, and will they face federal charges for doing so? Will individual D be found, or have they successfully escaped? And most critically, will Witness 14 survive long enough to testify at trial? This is not entertainment. This is not another true crime story you watch for drama and then forget. This is a live stress test of whether the American legal system can still enforce accountability when defendants have unlimited resources and no moral boundaries. There is no middle ground here. Either justice functions or it does not. Subscribe to this channel right now. Tomorrow's bail hearing could determine the entire trajectory of this case. Turn on notifications because I will update you the moment any new developments break. Share this video with anyone who still believes the system can work. This is history happening in real time, and you need to watch how it ends.